The essential element of nikah, or the marriage contract in Islam, is the form of contract, or offer and acceptance. The condition for concluding a valid marriage contract or making an offer of marriage or acceptance is the possession of legal capacity. Thus, offer and acceptance must be expressed by a person who is major and sane. In addition to this, the parties to the contract must be present in the same session of the contract, either themselves or through authorized agents. Offer and acceptance made by an infant and an insane person who cannot understand the meaning of their statements are not valid. A contract based on such statements does not come into existence at all. The age of majority is linked to puberty, which in turn is linked with ejaculation in males and menses in females. In the absence of physical evidence of puberty, puberty is presumed for both males and females at the age of 15, according to the majority of the jurists. Abu Hanifa said that the presumption of puberty for males in the age of 18 years, while it is 17 for females. Puberty is not a condition for the formation of the contract. However, an offer or acceptance expressed by a discriminating minor is deemed valid for the formation of the marriage contract, but is subject to ratification by the wali, that is, a person who has been given authority over the minor by the Shariah. The parties to the contract must be present at the time of the contract, either themselves or through their agents or messengers. The contract of marriage is not concluded when one of the parties is absent without valid representation. The acceptance may be delayed somewhat after the offer is made, but must be issued within the same session or location of the contract. A marriage contract may be concluded through an agent, whether for one party or for both parties. In certain circumstances, it has become a necessity for a woman, as she does not come out in the session of males where the marriage contract or nikah is being performed. Witnesses for the agency itself are not required. An agent in a marriage contract is different from an agent in other contracts, like sale, insofar as he is not responsible for the performance of the contract. In a marriage contract, the agent is more like an ambassador or one who expresses the offer or acceptance on behalf of the party to the contract. If one of the parties is not present and the contract is concluded by means of a messenger, the contract is valid if the letter is read out to the other party in the presence of witnesses and the acceptance is issued in the presence of such witnesses. A contract of marriage made by an unauthorized agent acting on behalf of both parties, when the parties are absent from the session, is not concluded even if such a contract is ratified later by both parties. If two unauthorized agents, one acting for the groom and the other for the bride, enter into a contract of marriage for the parties, the contract is valid if it is ratified by the parties. A valid marriage contract can be concluded between a man and a woman when either one of them or both are in a state of ihraam, with the condition that marriage will be consummated after the ritual state of ihraam has ended. The same applies to a marriage contract concluded when the woman is undergoing her menstrual period or is passing through the postnatal period.